laws. And it's true. And that gives me a certain perspective, I think, on both of those laws, because I can remember when they were passed and we were looking at legislative history and following the regs as they evolved from the very beginning. So I have lived with those from their inception, and I think that gives me a certain perspective. Justin also mentioned that this is not your nuts and bolts introductory level talk about ADA or FMLA. We're going to presume a certain base knowledge, and I think this is going to be more of an intermediate to advanced discussion of ADA and FMLA as we look at some practical issues. So let's dive into it. And I've broken this down in terms of presentation into 10 best practices for leave management. It seems like whenever people do these, it's always a list of 10. And so being an adherent to tradition, I'm doing the same thing. Let's quickly walk through that list, and then we're going to circle back and talk about each of those 10 best practices in greater detail. So number one on the list, truly, is training supervisors and managers to report employee health issues to HR, because an organization is liable for what its supervisors and managers do and what they know. So to the extent your supervisors and managers are aware of employee health issues and don't convey that to the organization, and I'm thinking in particular to HR, then you can be caught short as an organization by not knowing about it. Whenever you're tackling an employee health issue and the possible need for leave, you've got to consider all of the possible bases for an employee's entitlement to leave. So that could be the FMLA, it could be the ADA, it could be under your state's workers' compensation laws, or it could be under the very policies and practices that you as an organization have adopted or adhered to. You have to have the right policies and forms in place. That's best practice number 3. A lot of times with the FMLA in particular, it comes down to a battle of the forms, and you want to be able to win that battle. Fourth, with FMLA, you have the right to require employees to submit a certification of healthcare provider from the employee's own doctor or that of the employee's family member. And you always need to make sure that certification is authentic, clear, and complete. We'll talk about what that means. You need to recertify FMLA annually, which the law permits, and when circumstances change, which we'll talk about. Number 6, don't be bashful about requiring medical information from your employee. Some employers have this notion that HIPAA applies and they can't ask invasive questions, but the law gives you considerable leeway in making medical exams or inquiries, and you need to exercise your rights there to make informed decisions. Number 7, establish and enforce boundaries for the employee's use of leave, especially for those employees who perhaps are using FMLA or ADA as more of a sword than a shield and are always trying to push those boundaries. Number 8, recognize leave of absence as a possible ADA accommodation even when FMLA has been exhausted. Don't think that the exhaustion of FMLA extinguishes an employee's possible right to leave. Number 9, use return to work and fitness for duty assessments whenever necessary, and we'll talk about when they are in fact necessary. And number 10, under the ADA, engage in the accommodation process when required and document it properly. And we will review a form that will help you in that endeavor to document the ADA accommodation process. So take a look, if you will, at the handout, which is the case studies for this webinar. And if your time permits, review the first case study in particular. That's the one that we're first going to tackle when we finish reviewing the 10 best practices. And we will use that to apply our newly acquired knowledge, or newly refreshed, let's say, knowledge. Okay, so let's dive into the 10 best practices. The first one is issue recognition for supervisors and managers. You've got to take the time and effort to train supervisors and managers so they know what they need to report to you in HR. They need to be a conduit, not a filter. So they need to understand when FMLA may be in the picture. And there's this common notion that, well, FMLA applies when you're absent for more than 3 days. And that is true, but FMLA can apply to other situations before the employee has ever gotten to more than 3 consecutive days. For example, single days of absence for the same chronic condition, or for family health situations. So if your supervisor or manager is receiving employee call-offs, for example, or having conversations in the shop, in the office, about the employee's health circumstances, the supervisor may know more than you do about the common thread that connects an employee's seemingly isolated absences, and you need to be aware of that common thread in order to recognize if FMLA has been triggered. So does the employee cite a certain health reason for their absences? Do they cite a health reason for their performance issues, if that is the case? If so, then your supervisors and managers need to know to come to you, raise the red flag, and then you need to consider whether you have enough knowledge to suspect that FMLA may be in the picture. Because keep in mind, the employee does not have to use those magic words. I hereby invoke my right for FMLA leave. If you have enough information to know that FMLA might be in the picture, then you've got to manage that. So when it comes to issue recognition, next slide, we need to look at making sure your managers have some notion of what a serious health condition might be. There's a multi-pronged definition of that. They need to understand what a disability is and recognize that the bar is set pretty low nowadays after the ADA Amendments Act of a few years ago in terms of what is or is not a disability. They also need to understand what a compensable injury is under your state law in order to recognize those possible injuries and deal with them appropriately. And each of these mean different things, and the same medical condition might qualify as a serious health condition under the FMLA, and it might also be a disability under the ADA, and we want to make sure we afford the employee their full protections under both and not miss anything. So I have an example in the PowerPoint. It's an employee who has a mild hernia which does not substantially limit the employee's major life activities, but requires an operation. So in that situation, assuming the employee is otherwise eligible for FMLA, having worked for at least a year, having worked at least 1,250 hours, etc., then that employee would be protected under the FMLA, if for no other reason than because the operation will involve inpatient care at a hospital. And that is one of the prongs of a serious health condition. Then you have to ask, well, does the ADA apply to that situation? And the mild hernia that is properly repaired through an operation probably does not rise to the level of a disability under the ADA. So you're not likely to have to accommodate that after they return to work. And then obviously with workers' comp, the question would be whether or not the hernia occurred in the course and scope of employment, at least under Ohio law, that would be the standard, or whether it was substantially aggravated at work, even though there was a pre-existing non-work related condition. So again, that's just an example of where you have to look at each statute and determine whether it applies, and then make sure you afford the protections of those statutes that do apply. Okay, let's jump to best practice number 2. Consider all sources of leave entitlement. That's really where we've been. You've got to look at whether or not ADA is in the picture. And frankly, if you're an employer with 15 or more employees, then you are covered by the federal ADA. And many states have ADA equivalent laws. In Ohio, if you're an employer with 4 or more employees, then you're covered by Ohio's ADA equivalent. And I suspect that's true in many other states. With the FMLA, you only have to be worried about that if you employ 50 or more employees, and if the employee is eligible, and if they work at a facility that has 50 or more employees within a 75-mile radius. And then finally, all employers are covered by workers' comp laws, and all employees are covered by those laws without regard to part-time, full-time, length of service, etc. So you have to consider eligibility, as I mentioned. The ADA applies to everybody, including applicants. So does workers' comp. With the FMLA, you have those requirements of having worked for at least a year. That year does not have to be continuous, and the employee must have worked 1,250 hours in the year prior to when their leave would commence in order for the employee to be eligible for FMLA. Let's jump to best practice number 3. Have the right policies and forms in place. So it's important to have a really solid FMLA policy in your handbook. And the FMLA was the first federal law that mandated that if you had a handbook, then you had to have an FMLA policy in that handbook. And that policy can be your best friend if properly drafted. And keep in mind that the FMLA gives employers certain options to elect. For example, what one-year period are you going to use to measure FMLA? That needs to be set forth in your policy. Are you going to require employees to use accrued leave time like vacation concurrently with their FMLA? That needs to be set forth in your policy as well. So start with a good organizational FMLA policy in your handbook or policy manual. Secondly, you need to be familiar with and use the DOL FMLA forms. You know, employers are permitted to create their own forms if they want to. And I've heard so-called experts say that's a great idea. But frankly, given the constraint you deal with, which is that you cannot ask for any more information than is requested in the DOL forms, I think that begs the question why you would go to the trouble and expense of generating your own form rather than just using the DOL forms. So if you use those in a timely and proper way, I think you're putting the employee in the proper box in terms of their usage of FMLA. So by those forms, I mean the Notice of Eligibility of Rights and Responsibilities. That's DOL form WH-381. And that has to be given to the employee within 5 days of the employer having knowledge that FMLA might be in the picture, that they are missing work or expect to miss work because of an FMLA qualifying condition. So that needs to be timely delivered. And then you should, frankly, simultaneously give the employee the certification of healthcare provider. There are 2 forms, one for the employee's own serious health condition, one for that of the family member. And you should give that to them when you have knowledge that they might need leave, and then they have 15 days in which to have that form filled out and returned to you. And then, once you get all the information that you need, you must designate the leave as FMLA or not within 5 business days, absent unusual circumstances. And again, that designation notice is DOL form WH-382. And make sure you check all the boxes properly, including boxes that address whether or not the employee is going to be required to use paid leave while they're on FMLA. And it also addresses whether or not they will be required to provide a fitness for duty certificate before returning to work. So using that form makes sure that you protect all of your rights in those important respects. Okay. Best practice number 4 zeroes in on the FMLA certification of healthcare provider form. And it's very important that that form be authentic, clear, and complete when returned to you by the employee, having been completed by the employee's doctor. And you all may have opinions about how often it is the forms you get back are not authentic, clear, and complete. But I would place that at north of 50%. I think a majority of certifications that I see are not really clear and complete. So when they're not, if you have questions about authentication, for example, I had a case recently where there was one line on the form that was clearly written in different handwriting with a different pen, and we went back to the doctor and said, can you confirm that everything on this form is from your office? And they zeroed right in on that entry and said, nope, that's not ours. And so we surmised that it came from the employee doctoring the form after received by the doctor. So you're allowed to go to the healthcare provider, send them the form, and ask them to confirm that everything on that form was completed and or authorized by that doctor. So, clarity. I find a lot of forms that are not complete or not clear, and there you have to give the employee an opportunity to cure that deficiency by giving the form back to them and stating in writing how that form is not complete, if that's the case. So, for example, a common one in my experience is where the doctor has indicated the employee will need intermittent leave, but they have not completed the expected duration and frequency of those intermittent absences. And oftentimes the doctor will write uncertain or unknown, which frankly is perhaps a fair commentary, but it is not a sufficient answer under the FMLA regs. You can in fact require the doctor to guess, to fill in some parameters for the duration and frequency of the leave. And then when it comes to managing that intermittent leave, those parameters become very important, which is why you can't let the employee and or the doctor get away with an uncertain or unknown response to that question in particular. So, best practice number 5, the new certification and recertification. Those are two different things. So when a leave lasts beyond a year, and typically there we're talking about intermittent leave, which is why the 12 weeks of leave entitlement might span more than 52 weeks, you are required, or you are permitted to require, a brand new medical certification from the employee and his or her healthcare provider. And that new certification is just like the original certification in the sense that you can authenticate it, clarify it, confirm that it's complete, and invoke the second and third opinions under the FMLA if you think that is necessary. And then separately, there is a recertification process. So if the circumstances under which the employee is actually using FMLA deviate from the leave that was projected on the original certification form, then you can require a recertification. So an example would be where the form says the employee is going to be absent for a day or two at a time, once a month, and you find that the employee is missing a day or two at a time, 3 or 4 times a month. Those circumstances have changed. You're permitted to go back to the employee's doctor, describe how the employee has actually been using their FMLA, and ask the doctor to describe or explain to you whether the employee's usage is properly explained by their medical condition. And in admittedly rare instances, you'll find the honest, scrupulous doctor who will say, no, I can't explain why my patient is using as much FMLA as they are. It's not, in my view, due to their medical condition. Keep in mind that that recertification process does not carry with it the right to a second or third opinion. All you can do is get a new certification from the doctor. Okay. Best practice number 6. Do not be bashful about asking for medical information. So, as a pet peeve, let me tell you that HIPAA has no place in this conversation. HIPAA applies when you as the employer receive information about the employee through your insurance plan, for example. It has nothing to do with the information that you get from the employee or the employee's healthcare provider directly pursuant to your rights under either the ADA or the FMLA. Now, to be clear, when you get medical information about the employee through those channels, i.e. the ADA or FMLA, you are obligated to preserve the confidentiality of that information. But the ADA and FMLA do not prohibit you from making those inquiries in the first place. In fact, under the FMLA, it expressly provides that you can require the certification from the healthcare provider. And then under the ADA, you're allowed to ask for medical information or conduct a medical exam anytime it's job related and consistent with business necessity. That's the standard. And so examples of when that standard would be satisfied would be because you have a workers' comp claim involving the employee, or because you have a good faith doubt about whether the employee can safely and substantially perform their job based on some medical condition or physical limitation, either that you have observed at work or that the employee has reported to be struggling with. So there are ample opportunities under both the ADA and FMLA to make medical inquiries, and any decision you make under the FMLA or the ADA needs to be based on good, reliable medical information and not based on yours or mine's layman's notion of an employee's physical abilities, restrictions, limitations, etc. And so in the first instance, I almost always recommend that you seek the medical information that you need from the employee's own doctor. Not necessarily because it's the best source of the information, because the doctor might be biased and might be inclined to provide information that supports his or her patient's position. But bypassing a request for information from the doctor can look a little bit awkward later on if you're trying to explain or justify why you dealt with an employee the way that you did. So getting information from the employee's doctor is the starting point, and that is certainly where you need to start with FMLA. But under the FMLA, you also have the right to a second opinion by a doctor chosen by the company. It simply needs to be a doctor other than one you normally employ for other employment purposes, such as for your pre-hire medical exams, if you do those. And under the ADA, you're allowed to get information from the employee's doctor, and if you want, send the employee to a doctor of your own choosing for a fitness for duty exam, or to get an assessment of the employee for purposes of having an accommodation dialogue with the employee over accommodations that they might need due to a disability. And then under workers' comp laws, those vary from state to state, but I think they universally recognize that the employer has a need for and a right to get medical information about the injured worker in order to handle that claim. So, scope of medical exams and inquiries, I think we've touched upon that with the FMLA. You cannot ask for anything more than is set forth on the DOL certification of healthcare provider form. You cannot expand the inquiry beyond that. With the ADA, you need to make sure that your inquiry to the employee's doctor is properly tailored to the situation that you're dealing with. So, for example, if the injury that causes you to question the employee's ability to do all of his or her job is a back injury, for example, you cannot ask for all of the employee's medical records from the beginning of time to the present time. You need to focus your inquiry on the back condition and its impact on the employee's ability to do their job. If you don't properly focus the exam or inquiry, that would be an overly broad inquiry and could be unlawful under the ADA. So make sure that, if you have an employee sign an authorization for the doctor to release medical records to you, that the scope of that authorization is properly tailored to the injury that you're dealing with. Okay, best practice number 7, establish boundaries on an employee's use of leave. So with the FMLA, you need to make sure that the employee's FMLA usage is consistent with the certification. You also need to make sure that the employee's usage is properly authorized by the FMLA. In other words, that it's a qualifying condition. And I'll give you an example, ripped from the headlines as recently as last week. I had a client send me a certification where the pediatrician for a newborn child wrote a certification form indicating that the employee needed to use FMLA intermittently after the birth of the child because the child would undoubtedly have the normal childhood illnesses that any child can be expected to have. And my reaction to that was that under the FMLA, an employee is not permitted to use FMLA intermittently after the birth of a well baby, absent the consent of the employer. In other words, it's a privilege but not a right. And the certification was really saying nothing more than this is a well baby who may get sick during the first year. And so on my advice, the employer denied FMLA based on that certification by saying if and when the child is actually sick during the first year, and if that illness happens to be a serious health condition as defined by the FMLA, then at that point, you can fill out a certification form, we'll look at it, and we'll grant you FMLA, but not otherwise. So that is a case example of making sure the employee's usage of FMLA is consistent with the statute and the regulations. Another boundary, if you will, is making sure that the employee is able to and is performing all of the essential functions of the job. And I know the essential job functions can be a murky area, but I think employers have to take a stand when it comes to defining what those essential functions are and doing their best not to relieve employees of performance of those essential functions just because they have a disability under the ADA, because it is a per se undue hardship, a per se unreasonable accommodation to be required to relieve an employee of performing essential functions of the job. You are only required to remove non-essential functions from a job as a form of accommodation under the ADA. So determine what those essential functions are and stick to your guns on those functions. And then conversely, when an employee is working under medical restrictions established by either the employee's own doctor or the company's doctor, you need to make sure that the employee does not work beyond those restrictions. Hold them to it. And one reason for that is to the extent they stray from the restrictions, you increase the risk of them being injured at work, and you might very well turn a medical condition that is not a workers' comp related injury into one that is, because of substantial aggravation. So be careful about that. And then require new medical information whenever the employee claims that his or her circumstances have changed. So if you have an employee who's already working under restrictions and they say, I need more, or I can't do what I used to be able to do, you are not obligated to, and you are not well advised to take the employee's word for it. I think you want medical documentation to make sure that that is the medical situation truly has changed. Okay, best practice number 8. And it's pretty obvious, but yet overlooked often enough. So the employee comes to the end of their FMLA leave. They've used all 12 weeks and they're not ready to come back to work. And the employer says, well, we're done with that. No more job protection, no more employment, have a good life. To which I say, not quite so fast, because you might still have to accommodate that employee under the ADA. And might is an important word there. So let's take the scenario where the employee says, I know my 12 weeks are up and I'm not ready to come back to work, but my doctor says, give me 2 more weeks and I'll be able to come back and perform the essential functions of my job. Giving an employee a leave of absence is often considered a reasonable accommodation under the ADA. So you should not overlook that or automatically dismiss the possibility of granting additional time off to the employee as an accommodation under the ADA, even when FMLA has been exhausted. Now, important point, that leave under the ADA only needs to be for a finite period of time. So if the employee came to you and said, I don't know when I'll be able to come back, but I'm confident someday I can, it would not be a reasonable accommodation to write that employee a blank check in terms of the duration of that leave. So we have on the one hand the employee saying, I need a week or two, and my doctor says I'll be good to go, versus an indefinite leave. One, I would submit to you, you should reasonably accommodate them by giving them a leave for a finite period of time. The open-ended leave, I would say that is an undue hardship. We're not going to do that. And if you can't return to work, then we don't have a job for you. We can't hold your job. So keep that in mind. Now, if you're giving them some additional time off beyond the FMLA as an accommodation under the ADA, it begs the question, does that additional leave carry with it the same job protection as exists under the FMLA? And I guess the best answer I can give you on that is that there is a split of authority depending on where you might be with your employees, state by state, and frankly, federal circuit by federal circuit. So there are some cases out there that say providing employees a leave of absence as a reasonable accommodation without giving them job protection along with it is not really an accommodation. I think that's the minority view, but it's out there. Whereas other courts have said, you give them the reasonable accommodation of a leave, you no longer have to protect their job, and you deal with what job they come back to at the point in time when they're ready to come back to that job. So on that point, if you get in that situation, I encourage you to confer with counsel, make sure you understand what the prevailing view is, where your employment is, and then follow it. Okay. With workers' comp, I think I'd give you the same advice. I think your obligation to hold an employee's job when they're off due to a workers' comp injury is going to vary from one jurisdiction to the next. I can tell you in Ohio, for example, there is no obligation to hold the employee's job when they're out on a workers' comp leave, but I also know that that is not universally true. So I think you need to look at that on a case-by-case basis. Under the FMLA, obviously that is one of the prime tenets of the FMLA, that the employee is entitled to reinstatement to the same or a substantially equivalent position once they complete their FMLA. The notable exception being that unusual case where you can demonstrate that the employee's job would have gone away even if they weren't on FMLA. So for example, if all of the employees who hold the same position as the FMLA user had their jobs eliminated due to a reduction in force, you can eliminate the job of the FMLA user at that same point in time, even though they happen to currently be out on FMLA. So FMLA does not protect them to that extent. Of course, the burden would be on the employer to show that it is in fact the adverse impact has been for a legitimate non-discriminatory reason and not because the employee is using FMLA. Okay, I am up to best practice number 9. Use return to work and fitness for duty assessments. So remember I mentioned that on the FMLA DOL designation form, you're allowed to check the box that says yes, you will be required to provide a fitness for duty return to work slip from your doctor. And that's all you're allowed to require, is that simple statement from the doctor that yes, the employee is released to return to work with or without restrictions. And from that point, if you have concerns about whether the employee can truly do his or her job, or if the return to work slip does identify restrictions and you have concerns about the bona fides of those restrictions, then you sort of put the FMLA off to the side, you reinstate the employee without necessarily returning them to work, and then you follow your rights under the ADA for determining whether the employee can safely and substantially perform the job, whether you need more information from the employee's doctor, whether you want to send the employee to your own doctor for an exam to make sure they can safely come back to work. One situation where I think a fitness for duty assessment is critical is in what I call the miracle recovery cases. For example, I had a unionized employee who was off work for almost 2 years, and the collective bargaining agreement that applied to him put a 2-year limit on leaves of absence for medical reasons, at which point he would then lose his seniority and lose his job. And so at 23 months, this employee turned in a doctor's slip saying that they were completely healed and able to return to work without restrictions, which we characterized as the miracle recovery. And we were suspicious of it based on its proximity in time to his loss of seniority. And so we went the route of a second opinion or fitness for duty exam by a doctor of our own choosing to determine whether or not that miracle recovery was legit or not. And by the way, it was not. So that would be an example of where you want to use a fitness for duty assessment. Why do you care what the employee's fitness for duty is as they're coming back to work? Well, one reason being, again, that avoiding a substantial aggravation of a non-work injury, which will all of a sudden turn it into a workers' comp claim for you. So you're protecting against that, if nothing else. So I think we've touched upon the differences in return to work rights. FMLA is very limited. You accept the return to work slip from the employee's doctor. If you're not satisfied with that, then you really need to switch to the ADA and justify any further inquiry under the ADA, under that job-related and consistent with business necessity standard under the ADA. And that could include going back to the employee's doctor for more information or having the employee examined by your own doctor. And with workers' comp, again, that might vary from one state to the next, but I know in Ohio, an employer is certainly permitted to require a return to work certificate from the employee's doctor before letting the employee come back to work. I want to talk for a minute about light duty versus accommodation, because I see a difference between those two. With accommodation under the ADA, you are looking to modify an employee's job in order to enable them to perform all of the essential functions despite them having some disability. But the key there is they are still performing all the essential functions of the job. The job still looks more or less like the job they previously performed in the job that all of their peers in that classification perform. Whereas light duty typically is created because an employee has suffered a work-related injury, they have been off work, and your motivation is to get that employee back to work as quickly as possible in order to minimize the lost time expense that you are otherwise incurring. And so light duty can take on a lot of different forms. It can even be what I call make work, where you simply create work that is consistent with the employee's restrictions in order to get them back performing some productive labor rather than sitting on the couch at home and deteriorating physically. And so if they're at least at work under your watch and supervision, you're more likely to get them back to full duty sooner than they might otherwise. So the point being that light duty and ADA accommodation typically look very different, and the two should not be confused. And last but not least, best practice number 10, I ask you to look at the other handout that I've provided to you, which is the ADA Interactive Process Questionnaire. So that is designed to walk you step by step through what you should be doing when an employee says to you, I have a health concern and I'm not sure I can still perform all of my job. And so in order to determine whether or not they have a disability, and if so, what accommodations might be necessary to enable them to perform the essential functions of their job, and then the critical question of whether or not those accommodations are reasonable under your particular circumstances. This questionnaire is sort of a step-by-step process that you should take the employee through, and it provides you an opportunity to document each step of the way so that you can reconstruct the accommodation process that you followed as you went along. So review that form, and I would encourage the next time you have an ADA accommodation challenge, give that form a test drive and see if it helps you. I do want to point out one thing on the form that I'm not real happy with, and I will fix it. After question number 9, question number 9 is review the employee's job description and job functions. Based on the review, is the employee able to perform each essential function of that job with or without accommodation? Very important question. But below that it says if the answer is no, stop here. And I think that is not where you want to be. If the answer is no, they can't perform the essential functions of the job, I still think you're left with the question, is there some other way we could accommodate this employee? And the one that comes immediately to mind, and if you jump ahead to question 18, you find it, you have to consider whether the employee can safely and substantially perform some other vacant position that they're qualified for. Because the ADA would also teach you that if you have an open position for which the employee is qualified, and putting them in it would not violate somebody's seniority rights under a collective bargaining agreement, then placing the employee in that alternative position is likely to be considered a reasonable accommodation under the ADA. So I think the stop sign after question 9 might keep you from getting to question 18, and I apologize for that. We need to consider both of those options. Can they do their prior job with or without modification? And if not, is there some other job that's open, available, they're qualified to perform, then we put them in it. Keeping in mind that if you do that, you pay them the appropriate rate for that job, not necessarily the higher rate they might have enjoyed in a different job. Okay. I have a couple questions that have been thrown at me. Let me pause and see if I can't answer that. What happens when the employer has sent the employee FMLA and short-term disability paperwork through certified mail and the post office has attempted 3 deliveries and had to leave notification they are attempting to deliver? Also, the employer has emailed 2 times the FMLA paperwork to the employee and they still do not reply within 15 days. Employee responds when it is him initiating the conversation, but not to anything else. Well, okay, so what the FMLA would say to you is if the employee does not respond within 15 days, then you do not have to treat the absence as FMLA protected until such time as the employee's obligation has been satisfied. And I suppose you could have questions of employee notice, but one thing I would do is drop the certified mail component and resend it by regular mail. And if you are sending it by email, I would argue that that is constructive proof that the employee has received it, and I would operate on that assumption. So again, the employee's failure to provide you the certification is no excuse. And a variation on the same theme is where the employee says, my doctor doesn't fill out FMLA paperwork, so sorry, I can't give it to you. That is entirely the employee's problem, not the employer's problem. It could be that the employee needs to find a new doctor, but you as the employer are entitled to the paperwork. So you also have to consider circumstances where you want to, hang on one second. Hello? Sorry, I thought there was the moderator calling me on my phone. My apologies. you have to consider certain circumstances where you are willing to certify the absence as FMLA, even if the employee does not return the certification. I'll give you a fairly common example where you have a pregnant employee who has prenatal complications and is missing work before the delivery of the baby. A lot of times the thought process for that female employee, which is perfectly understandable, is I want to keep my 12 weeks of FMLA for after the baby arrives. But all those prenatal complications and absences from work because of it are in fact FMLA absences and can be treated as such by the employer, even if the employee resists or fails to respond to the request for certification. So occasionally the employers had to go ahead and certify even in the absence of the paperwork. So let me look at the next question. Do I understand correctly? You cannot require every employee to go for a fit for duty with the company doctor if their doctor has signed a release to come back to work from FMLA. Yes. So if the employee's doctor has said the employee can come back to work with no restrictions, as a matter of FMLA law, you need to accept that and reinstate the employee. However, if you, based on all the facts and circumstances as the employer, have a bona fide question or doubt about whether the employee can safely perform the job, then you slip into ADA mode and you do your exam or inquiry under the ADA independent of the FMLA. And again, an example of that would be my miracle recovery case, where you have reason to doubt whether the employee truly is healed and whether they can perform the job. But looking at the FMLA standing alone, your obligation is to accept the return to work certificate at face value and reinstate the employee. Okay, in the few minutes we have left, I would like you to read, if you would, case study number 1. I'll give you a minute to do that, and Justin will post a polling question relating to case study number 1, and it will be interesting to see how you respond to that polling question. So take a minute to read case study number 1, please. Before we jump to the case study, and perhaps while you're reading, let me jump to another question that has been posed. Can we move an employee to a different position if we feel their mental illness is preventing them from performing their essential job functions in their current position? The word that jumps out at me in that question is the word feel. So I would say if you have good medical documentation about an employee's restrictions or their ability to function, which includes mental functioning, such that you have a basis for saying they cannot perform their current job, then I think the answer is yes, you can move them to a different position. And that would be characterized, in my view, as a reasonable accommodation under the ADA. You cannot force an accommodation on an employee who doesn't need one, but if you can substantiate that this person is not performing in their current position, then transferring them to another position would be a defensible accommodation under the ADA. All right, so with case study number 1, let's see what the how we're doing on the polling results.
It looks like, Jim, we have 61% saying yes and 40. It's going up. We still have 34% of people voting, so it seems like they're still coming in here, but the majority are saying yes at the moment.
Yeah, so the majority, it's running like 60-40 roughly, that the company can terminate Chad. So let me go against the flow then a little bit. I think if you put on blinders, you might be justified in saying that. But I think the problem is a lot of things have been handled badly before we get to that point of the recent string of attendance issues. So let's take it from the top. So it says that Chad has worked for 6 years, which is at least half of what you need to know to determine that Chad is FMLA eligible. You'd also want to make sure that he worked the requisite number of hours in the year prior to his FMLA use to know whether he's FMLA protected. And then in that very first paragraph, it talks about how in the last 12 months, he's used all of his paid time off. And, that begs the question to me of why he was missing so much time, especially when you go down to the second paragraph and you see that Chad has been giving his manager letters from his doctor about carpal tunnel, missing work, doctor's appointments, etc. I think that goes to my best practice number one. Has the manager recognized the possible implications of FMLA? Has the manager informed HR that Chad is missing a lot of work or missing some work because of carpal tunnel syndrome? And even if all he's doing is missing work for medical appointments, it should still be treated as FMLA. So then let's go to the third paragraph. In April, Chad is missing a lot of work, sending all these rambling text messages, again, to his manager, not to HR, about a variety of excuses for his absences, some of which, in my view, might be FMLA protected, like his child is becoming sick while at work. That suggests more than one time. It's possible that those sicknesses are all strung together by a common cause and might be a serious health condition. He's going to see his father who is ill. I'm wondering if his father has a serious health condition and whether that should have been treated as FMLA. So to the extent he has all these absences that were not afforded FMLA protection, and you are now going to terminate him based on attendance, that termination is a risky one if it relies in any part on absences that could have and should have been treated as FMLA. So I guess that would be my concern about terminating him. Now, in the third to last paragraph, it talks about Chad asking if he can work from home when needed. And there I would caution you. I think a lot of employers might have a knee-jerk reaction that says, well, wait a minute. Working at the work facility is an essential function of the job. Working from home is an undue hardship. And that can be a good argument, but keep in mind that every accommodation decision you have to make is decided on a case-by-case basis. And there are, in fact, cases out there that say that working from home is not an undue hardship on an employer. It might be a reasonable accommodation. So don't reject that out of hand. But I would also say that whether or not he should be allowed to work from home as a reasonable accommodation depends on whether or not it's necessary. So before you even go down that road, you've got to go through the accommodation process. Don't be bashful about asking for medical information to determine whether or not he actually needs to work from home because of some bona fide disability.
Sorry, I'm typing here, Jim. I got you on audio. We have one person saying that they can hear nothing. I'm hoping that other people can. I'm not sure if we're having audio issues, but I'm hearing you loud and clear. So I'm assuming everybody else can. It was from Rachel. I'm just trying to work this out, but Assuming
Okay.
everybody has audio, if somebody can let us know that we are coming through loud and clear in our question section or our chat box, that'd be just great. If you're having any issues, please let us know. But Jim, please carry on.
Yeah, and Justin, we're winding down here, so let's jump to case study number 2 and ask everybody to take a quick look at that. And that also has tied to it a polling question that Justin can throw at you.
I'll throw the polling question out here, and also you can get your handouts under the handout section if you need to read those questions. We'll put the second one up.
Yeah, and just briefly, this is a case where the employee back in 2012 had stage 3 renal carcinoma, underwent surgery, cancer's in remission, and other than regular doctor's visits, he's not missing any significant time from work at the present time. So as I break that one down, I would say that even though those doctor visits are very sporadic, they are in fact tied to a serious health condition, that prior renal carcinoma. And so he should have FMLA certification for that, even now 6 years downstream, so that when he misses work for a doctor's visit for that old medical condition, you are ticking off 8 hours of FMLA per day missed for that medical condition. So then what the company decides is, for business needs and customer service, all of the technicians, including Steve, our case study, are going to have to work significant overtime, including at least one night shift every week. To which Steve responds, time out, that kind of schedule is going to put me in the grave. And he gets a note from his doctor limiting him to 8 hours per day, 5 days per week. Now, I should have asked a polling question on that. Who's seen that kind of doctor's note before? I've had countless clients come to me with that kind of note from an employee's doctor. And not coincidentally, I think, oftentimes it was an employee who was never very fond of overtime in the first place. So my radar goes off when I get those 8 hours a day, 5 day per week sort of notices. And so what do you do in that instance? I think you have to, before you decide whether you're going to accommodate Steve in the manner he's requested, you find out whether the accommodation is medically necessary. You go back to the employee's doctor with a series of pointed questions to have him explain or justify why that work limitation is necessary for Steve's 6 years downstream from his renal carcinoma with cancer in remission. And if need be, have Steve examined by the company's own doctor to determine whether or not he has a disability, and if so, whether the accommodation is necessary. So the polling question was, can the company make him work the new schedule? And 41% are saying yes, and 59% are saying no. And I guess what I would say there is, look at the next sentence after that question. Are there steps the company should take before requiring him to work this new schedule? I think if the employee has raised his hand and said, I can't do that because of a medical condition, the steps you take are the exam or inquiry process that we've been talking about, so that any decision you make is based on good, reliable evidence. And so when you jump down to the additional facts and you find that the company let him off the hook, and instead they say to him, we're going to send you to a new location where you don't have to work under this new schedule, but by the way, we've added 2 hours to your commute from home every day as a result, I think the employer jumped from the frying pan directly into the fire by going that route. I would have preferred that employer get good medical evidence and defend the new schedule, rather than what looks to me like a very adverse and arguably punitive transfer that rocks his world even more. But I think the one foundational piece here is, don't make these ADA accommodation decisions based on gut instinct, base them on good, solid, reliable medical evidence. So do we have any questions pending?
Not at the moment, but feel free to ask any questions if you have them. I did see a hand raised.
Over, but I'll stay on as long as people are firing questions my way, certainly.
Yeah, excellent. I do see a hand raised here. I think it's from Valerie, and I'm assuming that Valerie would like to ask you a question through audio. Is that okay, Jim, if we bring Valerie in here?
Absolutely, sure.
All right, Valerie, here we go. We're going to bring you through. Thanks for waiting. Valerie, can you hear us? Valerie, are you there? All right, looks like Valerie has left us. But if you do have a question and you're not able to type something in, just raise your hand and we'll bring you through. It looks like Ashley has one here. Ashley, we're going to bring you in. Hello, Ashley? Hello, Ashley? Okay. Doesn't look like that's working too well for us, but if you'd like to come in and ask Jim a question, just raise your hand and we'll bring you through as best we can.
Yeah, I tell you what, Justin, if anybody has a question they want to ask offline, they can shoot me an email. You indicated that you gave them my email address. They could call me. I'd be glad to answer a question or two offline if that would be helpful.
Awesome. Yeah, I did provide Jim's email address. It is J Wilkins, WILKINS at kwwlaborlaw.com. All right.
That's all I have, Justin. I appreciate you facilitating. Thank you very much.
All right. Awesome. Thank you very much, Jim. Thank you, everyone, for attending HR Simple's webinar series. If you have any questions, please contact Jim. And we will send out an email with the SHRM certificates and later on today. So thanks for joining us and have a wonderful week. Oh, well, hand up. Nope. Okay. All right. We'll let everybody go. Thanks again, Jim. We appreciate
Thank you,
appreciate
Justin.
having you on.
Okay. Bye.
Bye now.